I think it's when parents are unable to kind of filter considerations always going to be the best interest of the child, but it's the way that you enforce the court orders.
How do you help clients make rational financial decisions when emotions are run very high?
Yeah, I think it helps to do it over time. Don't want to put somebody in a position where they feel like they have to make a decision on the spot, but oftentimes it's very emotional at the beginning, but then as we start breaking things down into spreadsheet and numbers, that can help kind of remove some of the emotionality from it a little bit to help people see things in a more kind of sterile way. Things like the marital home can often be very emotionally charged assets and decisions that people make. So I think it's the lawyer's job to help people see it from a different perspective. Maybe they think, I have to keep the house no matter what. I think it's the lawyer's job to say, okay, if you want to keep the house, let's look at how much the mortgage is going to be and what are the other carrying costs that you're going to have and how's your cash flow going to support that. Sometimes I have clients work with financial advisors and other people like that, or they might have someone on their team already that can help them kind of look at those things, because if you're just making an emotional decision, you might on the other side realize it was maybe not the best decision because emotions come and go, as we all know.
Thank you. I totally agree with that, because financial complexities is one of the story, but when children especially are involved, the stakes feel even higher.
Yeah.
So what defines a high conflict custody case in your experience?
I saw that question and I thought, how do I know? I guess I know it when I see it. I think it's when parents are unable to kind of filter the conflict from the kid to the point where it gets disruptive. I mean, obviously there's situations where kids are present for physical abuse or verbal or emotional abuse, and that's kind of sticks out. But there can be other high conflict cases where it's maybe not that extreme or obvious. Maybe the police haven't been called, the social services hasn't been involved, but it can be like the point where people are non-functional. They can't agree on when a doctor's appointment's going to happen. They can't agree on any holiday schedule ever. Somebody's counting hours or minutes that they get with the kids. And that can be high conflict as well, even if nobody's yelling at each other. Wears everybody down, and I think it can have a negative effect on the children for sure.
It's quite draining.
Yeah.
I'm going to go back to that, but with another underlying issue when it comes to custody cases relating to children and the parents. So how do you protect a parent's rights while keeping the child's best interest at the center?
So in Massachusetts, the judge's core considerations always going to be the best interest of the child, which gives lawyers and litigants a lot of wiggle room and opportunity to provide a judge with the specific facts of that case to understand why one position or the other is the right one to take, and that why one parenting plan might be better for the kid. I think that it's important to give the judge as much information in a quickly digestible form and to really distill down to the core elements of whatever the conflict might be so that the judge can quickly get it. I don't think more words help in this situation. I think that it's about thinking through what really is going to move the needle in terms of the argument instead of just providing the judge with 17 years of history. The things that are more recent, I think, are more helpful for the judge to understand than what may have happened in the past. But if in the past there were significant issues of incidents of abuse or something like that, then the judge should certainly know about that. I also do a lot of coaching with my clients on the in-between stuff before court, maybe nobody's in court, or we're between court hearings, or we're trying to keep out of court and save some money, and some coaching on how to handle things better when they get an antagonistic message from their co-parent, or they're having difficulty with a transition or picking an activity, there are usually small adjustments that can be made that can help things, and at the very least can tee you up to be in a better position if you do have to get help from a judge, that you can explain to the judge what you did to try to fix it before going to court to ask for, additional orders or whatever it might be.
Okay, thank you so much. So it means you do support clients navigating parental alienation or communication breakdowns then?
Yeah, so those are tough cases where there is alienation or maybe a resist-refuse dynamic between a parent and child. I think that therapy and counseling are incredibly helpful tools in that situation, and having professionals look at the family unit and the dynamics. It can be difficult to get older children to participate in therapy or to, want to do it. Sometimes adults have the same problem and don't want to participate, but it can be, I think it's the best path forward, and I think that it should be tried prior to more extreme, measures of asking a judge to change custody or something like that. If you do end up having to get more extreme measures, it helps to have the therapeutic support in the background already set up when that happens, if possible.
So I was going to ask a question, but I don't think you've actually answered it, because I was thinking when it comes to behavior during disputes, impact and how it affects the children long term. But like you said, if they're able to go into counseling and learn how to have emotional regulation, the tools, it will help go a long way to support them in such high profile cases, especially when tempers or emotions are running very high. What are the most common post-divorce issues clients return with?
I counsel people, I represent people in post-divorce matters all the time. Sometimes it's a modification. Maybe parents were divorced when their children were quite young, and it is 5, 6, 7 years down the road, and child support or alimony needs to be recalculated. Maybe the parenting plan needs to be adjusted because the children are older and a different schedule might make more sense, or their activities, as they get older, their activities take over, school and sleeping. But so sometimes people just need to negotiate new terms due to the passage of time. There's also, I often represent people in complaints for contempt, which is the mechanism that we have. I don't know if it's the same phrasing in the UK, but it's the way that you enforce the court orders. If somebody has to pay child support in a certain amount and they don't pay, after a period of time, you can file a complaint for contempt, and that would be a hearing for the judge to look at the situation and decide if someone is in contempt, and then potentially order them to pay legal fees or other penalties for non-compliance.
It's applicable in the UK, but it's not as, will I say, stiff as in the US. Like the child support agency or child maintenance agency can step in and write a letter to the defaulting parent to say, look, if you don't comply, this is what we're going to be doing, so you better comply. Most times that actually sorts out the problem.
Yeah, we also do have child support enforcement agencies in the US, and they actually can talk, the different state agencies can talk to each other. So if you have a person paying child support who lives in Colorado and a person receiving child support in Massachusetts, those two agencies can talk to each other and enforce child support. For my clients, more common things would be maybe somebody not following the parenting plan on a repeat basis. You wouldn't go to court over one maybe mix up, or somebody not paying, not transferring an asset as part of that was set forth in a divorce agreement. If they still haven't transferred the retirement account or whatever it might be, then the way we push them to do it is to file a complaint for contempt after divorce.
Okay. Be safe and be positive. And don't forget to check out our social media handles. Thank you. Bye for now.